we will start the session. Thanks, everyone. Actually, the last hour of the day is always challenging for many of us, I believe. But again, we would like to acknowledge all your participation in this room. Kepisenangan greeting from my indigenous Dusun community. Greetings and greetings to all of you. And I will speak today as an indigenous person carrying out the voice of our community and also ancestors. I would like to thank to all the co-organizer, co-hosts creating this space and collaborate together. And also I would like to extend my respect to all indigenous leaders, allies, participants, and it is honor to moderate this important dialogue or discussion. The session is co-organized by a few organizations like Asia Indigenous People SPEC, together with the Lawyer Association for Human Rights Nepalese Indigenous People, Association of Indigenous People, Defender of the Archipelago in Indonesia, Cordillera People Alliance in the Philippines, and also the AICHA, ASEAN Intergovernmental Commission on Human Rights, Malaysia, and also Bangladesh Indigenous Peoples Forum. Allow me to introduce briefly about this discussion of the day. This is the topic of human rights due diligence and accountability for indigenous community in Asia. For those in this room before of this session, I think you have seen one of the conclusion of the Mentimeter exercise is we wanted the mandatory, not the voluntary measure, right? So please allow me to introduce today. This discussion is indigenous people in Asia have safeguarded their land, territories for generations, yet face increasingly threats from different challenges, extractive industries, energy projects, tourism, and conservation that often proceed without their consent, despite commitment under the UNRIP, United Nations Declaration on the Right of Indigenous People. Implementation remain weak, leaving community vulnerable to disposition and cultural loss. This session will look into the challenges that we are facing, as well as highlighting indigenous perspective, exploring recommendation to strengthen rights, accountability, and meaningful participation in the development process. And this session will aim first to highlight the human rights violation indigenous community face, such as land grabbing, displacement, violence linking to the extractive industry, energy, tourism, and large-scale project. And secondly, to also promote indigenous people's meaningful participation and what is important for them to include in the decision-making process, as well as grounded the right to free, prior, informed consent and self-determination. And thirdly, to recommend a stronger accountability for the human rights and environmental due diligence, and what will be the role of National Human Rights Institution and the ASEAN Intergovernmental Commission in protecting indigenous rights. So with that point, let me start or introduce our first panelist who will share insight, issues, as well as the opportunity from the Philippines. On my right side, we have Sarah Bestang Dekdekan as an indigenous Kankanai Egret from the Cordillera People Alliance. Currently, she is serving as the Secretary General of Cordillera People Alliance. So thank you for being with us. I think we would like to hear from your perspective, from your community, what will be the most urgent human rights violation linking to the land grabbing, displacement, development project, and how this effective to you community, social, cultural, and economic right. You have the floor.
Thank you, Frederick, and good afternoon, everyone. So I come from the Cordillera. This is a mountainous region in northern Philippines that is home to the Igorot indigenous peoples. And this region has long been targeted by numerous corporations for investments because it has rich minerals, especially gold and copper, and it has huge potentials to produce hydropower, geothermal power, and wind power, all of which are part of what is known as the energy transition. So for more than a century, our region has hosted 3 large-scale mining operations, and for more than 75 years, 3 mega dams. And from this, we have experienced and witnessed firsthand how such projects displace communities, destroy our environment, robs us of our livelihood sources, and deeply impacts on our culture and identity. So we have also seen how land grabbing and development projects threaten the very survival of ecosystems and indigenous peoples themselves, driving us deeper into poverty and marginalization. And these are continuing up to the present. And in addition, we are also experiencing the worsening climate-induced disasters like landslides and flooding, especially where mining and hydropower operations are located. And these have already cost us so many lives, homes, and properties damaged or lost, and food and water scarcity. And all of these have become all the more reason why we are committed in defending our lands and natural resources. But this remains to be an uphill battle, whereby despite the concrete impacts of these destructive projects in our communities, the government and private corporations still want to exploit and extract what is remaining in our lands, so that currently there are 197 applications for large-scale mining projects that are being processed. And in addition to that, there are 118 renewable energy projects that have been awarded by the government's Department of Energy. And all of these cover almost half of our land area. And these numbers are increasing every year, and most of these are also owned by foreign corporations. Now, it has been a part of our culture to defend our lands. So, of course, we protest land grabbing, displacement, and these so-called development projects. But in response, the government is intensifying its attacks, especially against our civil and political rights. The dangerous practice of red tagging and terrorist labeling continues to this day. We are being criminalized for defending our lands, myself included. And while there are national efforts and international standards to promote human rights and environmental due diligence, the laws continue to be weaponized against indigenous defenders, and this is meant to silence us. And the Anti-Terrorism Law and the Terrorist Financing Prevention and Suppression Act in the Philippines are increasingly targeting indigenous leaders. So more activists are facing trump-up charges related to this terrorism. And the worst part is for indigenous peoples, we have to bear the costs of legal defense, which is an additional burden to poor and marginalized indigenous peoples. And these laws, combined with counterinsurgency policies, are causing a lot of violations on our human rights and collective rights as indigenous peoples, while at the same time, the Indigenous Peoples' Rights Act in the Philippines, the UN DRIP, and the UN Guiding Principles on Business and Human Rights, and other international human rights instruments continue to be disregarded in practice. Another big concern of indigenous peoples in our country, is the constant violation of our right to free, prior, and informed consent, where the process is often railroaded or fast-tracked and manipulated through the collusion of the National Commission on Indigenous Peoples and the private companies involved. In some cases, over the past few years, some companies were even given permits or mining licenses even without undergoing the free, prior, and informed consent. So this outrightly violates our right to free, prior, and informed consent. Now, we have been asserting our right to FPIC and self-determination as indigenous peoples, but instead of listening to us, it seems that the Philippine government is even looking at FPIC as an obstacle in the implementation of various projects in indigenous territories, so that Now, the government wants to disregard this right by amending the FPIC guideline in the Philippines. It has also amended the renewable energy law and came out with several policies to fast track the processing of so-called development projects that undermine our right to FPIC and even our indigenous socio-political systems. Finally, I would like to share with you all that yesterday, representatives from our communities affected by proposed hydropower projects in Kalinga province, one of the provinces in the Philippines, they went to the office of the National Commission on Indigenous Peoples to submit another petition reiterating their non-consent to several hydropower dams. And then there, they were informed that the FPIC process for a few of these hydropower dams have been terminated, and the FPIC process for some other projects is up for termination. So, of course, this is a victory for us. Actually, it may be a small victory, but it is actually a result of many years of community protests and struggles, and it shows the importance of communities and advocates standing up no matter the extent of state repression. Because these communities have actually, over the past few years, been through intensified militarization, bombings, red tagging, and so many other forms of human rights violations. So this victory is hard-earned, but nobody should have to experience that much torment and rights violations in order that their non-consent to destructive projects is respected in a way. At the onset, when the indigenous people say no to projects, the FPIC or non-consent should have already been concluded. And of course, the fight is not over until the company involved completely withdraws and no other company takes over and the land is left untouched as wished by these indigenous peoples inhabiting these lands. Nevertheless, this is one good news that we hope would serve as an inspiration, especially to our fellow indigenous brothers and sisters in fighting for genuine, free, prior, informed consent and for self-determination of indigenous peoples. Thank you.
Thank you so much, Bestang, for your contribution. And it's good to know the victory, but I think we should not repeat the kind of challenges for our community as struggle only, and then we're able to have the success. Nevertheless, we'd like to continue with the next speakers. We will move to Nepal. On my left side, at the end, we have a Durga Manerai. He is the indigenous lawyer as well as a human rights defender over 23 years, as well as working with the organization called Lahunip, taking lead some of the initiative to support the indigenous peoples and also local community by providing legal aids, assistant community-led cases, as well as promoting advocacy to the challenges violation in different arena, the regional, international level, as well as engagement with the international financial institution. So with this space, can you please share your experience and what will be the legal gap aspect in your country, as well as you observe whenever indigenous peoples try to against the land disposition or violence around the extractive industry or any national project in your country, please.
Thank you very much, Fred. Thank you very much, brothers and sisters. This is Durga from the largest Association for Human Rights of Nepalese Indigenous Peoples. As you mentioned, we do the legal work in the defense of indigenous rights. So it's an honor to talk about the issues of indigenous peoples when it comes to business and human rights, including the development aggression that are happening in our traditional territories. So the indigenous peoples around the world actually, experiencing bad impact on their land territories and resources. And Nepal is not exception to this. the business activities or development aggression that are happening in our territories. For instance, protected areas, large scale of, the hydropower project, transmission lines, and the park and protected areas and large, the road expansion projects. So these are actually happening in our territories without obtaining prior and informed consent. So what I'd like to highlight is that we definitely know that the indigenous lands is life for indigenous peoples. So indigenous spirituality, indigenous sovereignty or self-determination, including cultural integrity and other rights, collective and individual rights, are deeply connected with their traditional lands. So the indigenous, such project actually happening in our territories, the violating the indigenous people's right, meaning that land territories and resources, meaning that the violation of indigenous people's land territories and resources is the violation of other rights that are linked to indigenous lands, for instance, cultural, livelihood, environment, and everything, and so on and so forth. So yes, I actually would like to talk about Nepal's legal system. As you know, the Nepal is the one that has ratified ILO Convention and UN Declaration on the Rights of Indigenous Peoples. And then if we look at the constitutional provision that talks about some cultural rights and the rights of indigenous peoples to participate in the decision-making process in the matters that affect them. And also it talks about, little about the principle of prior consent when it comes to environmental issues and utilization of the natural resources. And then we have filed the case in the Supreme Court, and that court ruling came out that says the local government, the provincial government, and even the federal government has to implement the ILO Convention and UN declarations on the rights of indigenous peoples. And another case that we have filed in terms of, the hydropower project, the one, the verdict came out from the Supreme Court that directed to the business communities, even to the government, that they really need to respect the indigenous people's right to, the ILO Convention and the UN Declaration, even that has ordered to implement the UN Guiding Principle on Business and Human Rights, and then including, the Declaration of, the Development. And also, the Nepal actually, the nationally determined contribution, that is, we all know that this is the climate action that is coming up from the government, and that has also recognized the prior and informed consent, and many other, the court has also the issue, some court jurisprudence that actually, order to the government and other business entities to respect the indigenous people's right. But the thing is that the implementation is quite zero. No implementation, right? We are dealing with number of cases relating to the hydropower project or the different infrastructure development. And we are looking into the case relating to the park and protected areas. We are looking into the case relating to the land grabbing and violation of indigenous people's right. No, the things are really serious. And then there is no actually any progress, I would say, and we are looking into the case, different community cases, for instance, hydropower project and transmission line, and that are related to the land grabbing of indigenous peoples. And also we are dealing with the different, the complaint mechanism or accountability mechanisms of the different financial institutions. For instance, World Bank, Asian Development Bank, including the European Investment Bank. But it seems that such complaint mechanisms are not really working well when it comes to indigenous people's right. So these are the things, and then I would really like to recommend some points. Is that Nepal is a party, as I mentioned, ILO Convention, and voted for UN RIP that has to be implemented. and the indigenous people's right to land territories and resources, including self-determination, which is very, very crucial for indigenous peoples. So that has to be implemented. Our indigenous customary rights over the territories has to be implemented. And the second thing is that the human right due diligence that we are talking about, that actually, holding accountable to the corporations. We are talking about human right, mandatory human right due diligence from the perspective of indigenous peoples, from the perspective of indigenous peoples. So human right due diligence is something different. So that has to be included in the due diligence legislation. And of course, Nepal has, endorsed the National Action Plan on Business and Human Rights. Definitely that talks about little about indigenous right to free, prior and informed consent, especially environmental issues, but not very much clear. So I think that that has also to be implemented. And another thing is that in the process of human right due diligence, and the AIPP is the mandatory provision that needs to be considered when it comes to human right due diligence, and that has to be recognized. And the second thing is that, and the last thing, the access to remedy actually. It's really terrible. Indigenous people have not access to remedy, right? So that has to be improved actually. So the indigenous legal system, indigenous judicial system has to be recognized when it comes to access to remedy. So finally, what I'd like to say, there are such development aggression or business activities that are happening in our territories without free, prior, and informed consent. This is actually a new form of colonization imposed upon indigenous peoples and indigenous lands. Thank you very much.
Thank you so much, Durga, for your intervention, as well as highlighting some of the gaps and also the recommendation, and also highlighting some of the important point that really to ensure look after the implementation level. Now I would like to turn over to the next speaker on my left side, beside me, from Bangladesh, Sanjeev Drong. He served as the General Secretary of Bangladesh Indigenous People Forum, founding president of Indigenous Peoples Development Service. He is also expert member of the Parliamentary Caucus of Indigenous Peoples and Minorities, and member of the Thematic Committee on Minority and Business and Human Rights of the National Human Rights Commission, Bangladesh, as well as he is active in the several civil society organizations. I think the question that we would like to pose here to you is how you can see important indigenous people meaningful participation in the decision making related to their land, and what such barriers that still exist whenever to implement the free, prior, informed, and consent. Please, you have the floor.
Good afternoon, Moderator Frederick. Thank you very much, and my friends. As you said that I was I think still I'm there as a member of the Thematic Committee of Business and Human Rights in the National Human Rights Commission. There is no commission now because of the political situation. It is inactive now, but still I think the committee continues. My experience has, to your question, I think the main challenge is the proper respectful recognition of indigenous people's rights in the constitution and in the policies and in the law. What I see in my country, Bangladesh. I was member of the Thematic Committee of the Business and Human Rights, yes. But if you see our constitution, even our other policies related to indigenous people's rights, I think there is a big challenge for indigenous peoples. And even my experience is that in the meetings of the thematic committee, that the UN principle, UN guiding principle, I think it is very good for any people, any citizens, not only for indigenous peoples, because it talks about the protection respect and remedy. So if there is no recognition or respect for the rights of indigenous peoples, including the free, prior, informed consent, etc., I think this is the big challenge what we face in my country. Even the denial of the existence as indigenous peoples. Our constitution says that it will protect the local culture of the tribes, minor races, ethnic sects and communities. They use 6 terminologies, not indigenous peoples, but ethnic sects, minorities and communities like that, tribals like that. So recognition is the main thing. And another thing is what I experienced in the committee, that the business groups, business companies, business associations, we have some business associations, they have very, very little knowledge about indigenous people's issues. This FPIC or even ILO Convention 107 for tribal, indigenous peoples and tribal population, or even UN Declaration on the Rights of Indigenous People. The good thing is the UNDP Bangladesh, they translated the UN guiding principles on business and human rights into Bengali language, into Bangla. This is good for, for dissemination of information. But the main reason is that there is a big gap about awareness. And another thing I would say, there is a lack of institutions, indigenous institutions, the barrier why indigenous peoples are not properly represented in the decision making process. So I think in many member states in Asia, even member states in Asia, it is important that indigenous peoples should have their own strong organizations, yes, but the national level, there should be at least Indigenous Peoples Commission or National Commission for Indigenous Peoples. Yes, I know I have many friends in the Philippines like Vicky, Joan and other, long ago, our friends. There are a lot of challenges, limitations, but I think still it is very important. We demand for National Commission for Indigenous Peoples, I think in our country, I think in many countries, so that they can bargain, they can discuss, they can consult with the government and business communities and other stakeholders. Among the 3 pillars of UN guiding principles, the one is the protection. It says the governments have the responsibility to enact policies, legislations and regulations to protect against human rights abuses by the business companies and corporations. So if any business companies or corporation violate human rights of indigenous peoples, or they go for grabbing indigenous land for making big companies, what will happen? Indigenous organizations often cannot, represent themselves strongly in the dialogue with government and these big corporations. So there should be some mechanisms. If there is a ministry for indigenous peoples and tribals, it is better, I think. So my point is also the capacity building of indigenous peoples organizations also is very, very important, so that they can engage with the dialogue with the government when they face violations of human rights. Another point is, the remedy. If we talk about the remedy, then it comes about the land rights or recognition of the ancestral land rights issues or customary land rights issues. If your customary land rights is not recognized, then how the remedy will be made there? So the land conflict should be solved before going for the remedy. I think this is also very, very important. That's why we have a land commission for the Chittagong Hill Tracts since 2001. So almost now 25 years gone, the Chittagong Hill Tracts Land Commission still could not function well. Still it is going on. So finally what I would say that we, the indigenous peoples, we should try our best to build our capacity of indigenous peoples' own organizations so that we can raise our voice, not against the business people, but to benefit, so that the business benefits also indigenous peoples. And also, we can talk the same table with the government representatives about the indigenous people's rights. So capacity building is very, very important here. Finally, I would say that this human rights due diligence is, to me, I think very, very important for us to protect our land rights, to protect our resources, to protect our forest, to protect our rivers, and etc. I give one example in short, like, there is a indigenous Santal area in the North Bengal. Government is planning to establish EPZ, is called Export Processing Zone on indigenous land. The Santal and other indigenous peoples are saying, we don't want this. We don't need this. But government is still, trying to do that. So the conflict is there. And in the Madhupur National Park area, there is a forest area, the national park was established in 1960s. Still land conflict is going on. And indigenous peoples are fighting for their land rights and right to forest and natural resources. So this is happening, and I think for this UN, guiding principle on business and human rights, I think can play a very, very good role if we can use this properly. Thank you very much.
Thank you so much, Sanjay. I think it's a good point that you also highlighting the challenges, but also recommend to communicate again ourselves, how we can strengthen our organization or mobilize ourselves to be able having a same table or dialogue with different stakeholders. Thanks for that remark. Now I would like to invite our next speaker. He will be speaking the regional perspective. We have His Excellency Edbon Bon here, currently serving as a chair, as well as the representative of Malaysia to the ASEAN Intergovernmental Commission on Human Rights for 2024 and 2026, his term. So I think you can share what will be the perspective or pattern after listening and even in your own area of work of the right of violation across the different region, but of course particularly in the ASEAN context, and how do a cross-border or transnational project exacerbate there's risk, particular to the indigenous peoples. Yeah, you have the floor.
Thank you very much, Frederick. Thank you to the fellow panelists who have been speaking very passionately about indigenous people's rights. I just wanted to share my own personal experience having litigated cases for the indigenous in Malaysia. We have managed to secure some victories on the basis of customary land rights. But the problem in Malaysia, as I mentioned before, and I think with our new national action plan, is how do we have a demarcation as to what indigenous land is and what it is not, because it's customary land, there's no land titles, and this is something which Malaysia has put into our national action plan to consider moving forward, providing mapping for indigenous land, so that there is no longer any more land grabbing and encroachments. This is going to be a work in progress because there's obviously a lot of commercial, corporate interests as well as state interests in using that land, and giving up that land to indigenous people will obviously, and recognizing indigenous people land will obviously create losses and create losses and loss of ownership as to that land for the state and corporations. So both state and corporations must bear responsibility and accountability for encroaching into land for purposes of commercial gain, and now with also the initiatives of climate and just transition about using lands for carbon credits and giving it up for purposes of sale and profit. So that is some context in our own country, but in my own country, but in the region in ASEAN, we still face these two problems that have been particularized just now. One is legal identity. Malaysia, during our chairmanship this year, has been leading the negotiations for the past 2 years over a declaration that is very contested regarding the right to a safe, clean, healthy, sustainable environment. And the word indigenous people has drawn objection from at least two countries in Southeast Asia, in ASEAN. These two countries say that indigenous people are not recognized in the constitution or not recognized in their laws because everyone is of the same nationality and same ethnicity. And so the argument goes is there should be equality and there's no special preferential treatment for the indigenous. Of course, for countries where indigenous people are recognized, like in Malaysia, we support the use of the indigenous peoples. And as part of the process, when we were negotiating the draft, we had referenced the UN DRIP. We have referenced at least no less than 5 times indigenous people in the draft negotiations. And the term indigenous people itself has been contested. While there are some other countries who said that using language such as ethnic minorities, ethnic groups, traditional groups, local communities are equivalent. But I think legally, the legal identity through UN DRIP and the term indigenous people is a more accurate term. And also because I think there is some backlash from the olden times, colonial times, as to what amounts who is an indigenous person who came first on the land. One solution to that, which is a long-term idea, is actually for groups and indigenous groups and lawyers here around the table to think about is how do we deconstruct the term so that the term then becomes a normalized term in terms of what accurate history is. Because during negotiations, I can say that there are countries who object to the term will come up with their own version of history. And negotiators like us who have and recognize indigenous people in our constitution and support indigenous people in Malaysia and using the term in ASEAN do not have that background of history. So when a country comes up with that net negotiation tactic and says, oh, because of this history, we cannot use this term, or because of this history, we don't recognize the indigenous people, then we need to try and contest and challenge that. When leading the negotiations, we were trying to do some research. And sometimes we don't know whether the research is accurate or not. But that's a challenge that we find during negotiations because we don't obviously have information of the historical narrative of how different indigenous people in different groups in different countries, the term have come about and why you recognize yourself as indigenous. So that is one challenge in Southeast Asia and one opportunity or one suggestion which will assist us at the Commission to push back on the narrative of some certain countries as to what the legal identity of indigenous people in that country actually means, especially when they don't have that in their constitutional law. The second issue I want to raise is what has been raised before in AIPP. AIPP in some countries are recognized in law, so they are constituted in law. In other countries, they're not recognized at all, but it is recognized as part of social and EIA assessments when you do certain big projects and social impact assessments. So it's not a law, it's more of a practice. I agree that we need to have mandatory FPIC, and so that push for legislation and lawmaking should be continued. But even for countries where it does not have FPIC mentioned, or it has FPIC mentioned, sometimes it's not properly implemented. So that challenge again came about when we were negotiating the ASEAN Declaration on the right to safe, clean, healthy, sustainable environment. As I mentioned before, I think the last panel, the declaration has been is going to be adopted in October for the 47th ASEAN Summit. And with any soft law binding, non-binding document, an ASEAN document, it obviously will have its critiques and it will also have those that welcome it. What I would suggest is once we have adopted it in October very soon, please have a look at it. And for us at the Commission, we would obviously use the positive points from the declaration to move things forward. Consistent with how customary international law as well as UN DRIP has described the rights and obligations of state towards indigenous people and how indigenous people are framed. This right to FPIC is something which continues to be contested, but we need to continue to advocate, one, for it to be made more mandatory in law and not just as a matter of social policy or social practice. And two, we need to, once we make it into law, then we need to make it justiciable, meaning if it's not followed, then the lawyers or the communities can actually take it up in the courts. So I just want to stop there, moderator. I hope that is sufficient just for the challenges, the two main challenges that we face at ASEAN at the moment, and how we have to continue working together to navigate these challenges. Thank you.
Yeah, thank you so much, Edmond. Yeah. I think with the highlighting of the initiative in the ASEAN, as well as pointing important question, I think hopefully this will also address in the discussion about how we can deconstruct the terms of indigenous peoples and how it can be normalized in the region. I think that's some good question for us to pose, especially in the discussion time. Now I would like to pose the space to the floor. If you can raise your hand, any question, but please keep it short, less than 1 minute each, if any in the room. Okay, in the middle, please.
Hi, I'm Ika. I'm from Indonesia. I'm coming from Pulp and Paper Company. I heard that AFPIC have been mentioned a couple of times by the panelists. I can use some guidance from the panelists in terms of implementing the AFPIC because we do experience some challenges on the ground. So my first question would be in terms of legitimate representative of the communities. How do you define who is actually the legitimate representative? Because we experience an issue where there wasn't a legitimate representative being involved and engaged, and then some community member deny the person as the representative. And then the second question regarding the consent being given. Is it communal or is it individual consent? Because when we did FPIC, there's a case where the consent being provided by the majority of the community member of the indigenous people for the sake of the economic benefit, but then there are some small groups of the communities who refuse to provide consent. So in the end, there is a horizontal conflict among them. So that's also very sensitive for us. So maybe I can use some insight from you. Thank you.
Yeah, thank you for your point and also question. Yeah, on my left.
Thank you. I'm Surti. I'm from Pepeman, from Indonesia. My question is, based on your share information about the environmental issues and human rights issues has not yet been clearly resolved, are there any best experiences that you can share to us? And the second is about the carbon project in Malaysia, how you can engage with the indigenous communities following the FPIC process and how to engage with the governments. Thank you.
Yeah, thank you for that question. In the middle. Yes.
Hello, Johar. This is Kokun Suitan Mumu from Bangladesh. I represent the Bangladesh Indigenous Peoples Forum, and I would like to thank all the panelists uh, for bringing out the issues on behalf of the indigenous peoples. And I also want to give thanks to the Young Voluntary Fund for supporting me to come here and represent. And all the issues that our indigenous panelists have brought the issues that actually um, about the meaningful participation, what I can say is that, but in our country, actually, all the cases that related to the export processing zone, where the indigenous peoples are in the threat of the eviction, in terms of also the social forestry, government social forestry, in terms of in Chittagong Hill Trucks, that five-star hotel implementations, that there is a loophole that with the UNGP's principle respect, protect and remedy, that government as well as the business corporation has a liaison and they have operated through the government. So I mean, make a government accountable and make a business accountable is kind of difficult loophole to progress on behalf of the indigenous peoples. So that's why that our Secretary General bring the term is we need a proper commission. I'm totally agree with that, and also that actually the indigenous peoples progressing through the mechanism and also the framework is sometimes difficult. What I'm trying to say is that because there is a loophole too, that government persuade the things like and making making actually the door that invisible. Where should we go? So that all the forums today I have joined is that like different corporations like through the Asians, like they have drafting many different human rights due diligence. But actually the thing is that there is no room for indigenous peoples to in the drafting different human rights due diligence that the corporation are offering through the mechanism of the process. So indigenous peoples need room, or indigenous people should be accountable there in the compliances process that they are drafting. So that's what I want to say.
Yeah,
Thank you.
I think we can take one more this side and then, yeah. Thank you.
Two quick questions. One on the question of history, which I thought was quite interesting and important. Is the suggestion that there needs to be a writing or a drafting of history from local groups who wish to claim some kind of, the identity of indigeneity, so like a homegrown history, as it were, or is the call for a more sort of like, an academic level sort of, sort of I guess, pre-qualification process, as it were, laying all of that out. And the reason that's significant is because there are a lot of groups who don't in fact have written histories. And to perhaps perform the act of written history would be in itself a form of, I guess, a non-indigenous, a way of telling and knowledge basing. Related to that question, I mean, there's a fundamental presupposition which underlies some of this discussion on FPIC on territory of land, which is territory, right? And a lot of indigenous communities, at least where I come from in Pakistan, um, don't actually have territories. There's nomadic agropastoralist practices. Some of them live on water and have historically only traversed up and down the rivers. And that kind of practice doesn't really fall easily into the kind of FPIC mechanisms that are being discussed at this point. So I want to know what practical steps would there be for such groups, particularly in cases where they no longer really exist because they've been decimated and therefore scattered and no longer able to subsist in the manner that is true to their historical practice and folk wisdom and folk history and all the cultural practices that go with it.
Thank you for your intervention as well as question. I think I would like to pose this question to Adbun, and I believe some of the question will also responded during the discussion intervention. Yeah, please.
It's a very good question. Two good questions. The second question I deal with first. I think at the commission we have received complaints on currently what we are working on in our communication mechanism is the Bajau Laut. The Bajau Laut in sea nomads, right? Stay off the shores in Sabah, and they are stateless. They cannot have medical health care, and at the commission, Malaysia, Philippines, and Indonesia are trying our best to see what we can do. And they live a nomadic life as well. I'm not saying that it's the same situation as what you're mentioning, but that challenge is something I at the moment I ask myself as well, and that commits themselves to it creates a situation where governments are non-committal as to even giving them citizenship or legal identity to get healthcare. Your first question actually is very interesting. I'm not sure how that kind of what kind of history needs to be written. I'm not asking for a rewriting of history, but for my limited experience working with the indigenous people in Peninsular Malaysia and sometimes in Sabah and Sarawak, is that a lot of this information, although there's no written history, it's important to document at least oral history of the community. Of course, there will be contested histories, and I think this is one challenge that we have when we face up to governments. If you want to say yes, maybe at academic level for deeper appreciation, but perhaps even at a very common level, countries are saying, okay, this is they are not indigenous because of this. How do we even deal with that at a very basic level? Because a negotiator dealing with even at the UN, right? If somebody says from this country that this indigenous is not really indigenous, how is somebody else going to say, no, this person, this group are indigenous? So we don't have that information to contest and compete on that basis because we come from a different country. So I'm just saying that's the practical problem that we have been facing when we are negotiating this type of documents. Just to let me respond there. Thank you.
Yeah, thank you, Edmond, for that response. Now, I hope we can also continue the response from your question as well as intervention, but I'd like pose to the discussion. Two speakers we have here, Dr. Binotamo Idamai. He is currently serve as expert member of the UN expert mechanism, the right of indigenous peoples. He's representing the socio-cultural region from Asia. I think if you can please share with us some of the reflection from the speaker presentation that we have heard earlier, and what will be the role of the mandate of MRIP, useful to share with everyone, as well as some of the question posed from the panelists, and also maybe can link with how do we deconstruct the terms and how this can be normalized in the region, and as well as important of recognition of the right of indigenous peoples. The floor is yours.
Thank you for the introductions. Thank you for the organizer. Thank you, the organizer and the speakers His Excellency Edmond Bontai Shun, as a representative of Malaysia, and Dr. Pichamon, the chair of the Working Group on Business and Human Rights, Indigenous brothers and sisters, and colleagues, friends. I would like to share with you very briefly about the AMRIP, and then I will try to share some of the thoughts about the indigenous peoples, the concept, and also the concept why it comes in line with the UN Declaration on the Rights of Indigenous Peoples as human rights, and why it is relevant to the identity and cultural issue. So while the topic is about the due diligence, human rights, I'm not sharing all of this very detailed. From my point of view, what I like to share, AMRIP in its mandate under the Human Rights Council underscored that due diligence requires states and business enterprise to take proactive, preventive, and corrective measures to ensure that indigenous people's rights are respected, protected, and fulfilled in accordance with the UN Declaration on the Rights of Indigenous Peoples. AMRIP also stands with the topic of the accountability that is necessary counterpart without effective mechanisms to hold duty bearers and corporate actors responsible. Human rights due diligence remains a rhetorical exercise. AMRIP's its own studies, as mandated by the Human Rights Council, have consistently underscored that accountability for violations against indigenous peoples cannot be separated from ensuring recognitions of their collective rights, their governance systems, and their participation in the decision-making. The issues affect them. Since time is very constrained, I'd like to share some of my initial thoughts about the indigenous peoples concept. So this is one of the biggest issues that we have always been talking, who are indigenous peoples. That's where the AMRIP actually comes up with their mandate, the country engagement. The country engagement is to clarify, to advise to the Human Rights Council and to the member states, to facilitate dialogue with the member states and indigenous peoples and other entities, and also at the same time to hold or organize any other avenues that require for attention from the different actors. Now the concept of indigenous peoples that we talk about, we should not think always what started from the nation-state building process or what started from the colonization and decolonization process. It goes beyond of all those concepts. Because indigenous peoples, as a traditional, centuries-old traditional society, they have their own governance system, they have their own unique culture, they have their own civil society, they have their own cultural practices that is very unique, different than any other entities, any other nations. That's why this separation that brings the unique identity for themselves as indigenous peoples, that because all their practices directly connected to their land, territories, and resources, that land they see as part of their ritual and their ritual practices, spiritual connections, and also a place for their not only cultural practices, but also their identity, language practices, knowledge practices, their governance systems, and that they preserve generation to generations, which if you see to any other society which is very different for indigenous peoples, that's why they step up, they seek their recognition as indigenous peoples to hold their old traditional customs and their cultural practices. So the United Nations itself provided some criteria in Martinez-Coburn definition. This is not a definition, it's the characteristics. In 1981 studies, actually started in 1971, and after 10 years, 1981, he submitted the report to the Commission on Human Rights, which provided some characteristics with this, while clearly outlined by saying that indigenous people, those are who are even before the colonization, pre-invasion or invaded, and so-called, I mean, all those colonial stuffs. So my point is here, when it comes to the identity for indigenous peoples, it should not be limited itself who come first. It should be something going beyond the discussion of this concept of so-called national state colonization and who come first. But going beyond the centuries old who are existed until today practicing their old traditional customary system. So that's what we talk about as indigenous peoples. We talk about our rights as a collective rights, why we emphasize. These collective rights, this is the basis of identity, our language, our culture, our governance practices, our knowledge practices, spiritual, ritual practices. That's the unique, that's the differences than any other society. Now, what it talks about the international human rights instruments in line with these collective rights. That's where we come from with the UN Declaration on the Rights of Indigenous Peoples. Yes, by nature, UN Declaration on the Rights of Indigenous Peoples, it's a declaration, it's not legally binding instrument, but the other way around it is legally binding instrument. This is the instrument in the UN system where 24 years between state and indigenous peoples together had the negotiation and agreed to all those languages, every single words, every single sentence, every single provisions of the UN declarations, point by point, both state and indigenous peoples going through, and they agreed upon, and this is the commitment they made. And these provisions of the UN Declaration on the Rights of Indigenous Peoples, it is nothing new. It is just separated from the other international human rights instruments, separated just for indigenous peoples. This is the thing. So, when a state can respect the Universal Declaration of Human Rights, which is the father of all international human rights instruments, the similar thing happened for the UN Declaration on the Rights of Indigenous People because this is the source. And this source came through the agreed upon between the state and indigenous peoples through the 24 years of negotiation. So in a way, this is ethically and legally binding instrument. So here is now the point of commitment for the implementations. If you can implement the Universal Declaration of Human Rights, why cannot the UN Declaration on the Rights of Indigenous Peoples, which is almost the same thing? If we also talk about our national constitution, most of the source of our national constitution is the source from the Universal Declaration of Human Rights and the UN Charter. Most of the states, they borrow the language from there. The same thing. We just place the indigenous peoples to every sentence. There's the thing, separated. So this is all about the political commitment and political will. Here we come through the UN mandate, through the Human Rights Council mandate, the AMRIP to advise how to promote and advance the rights of indigenous peoples. So that's why this country engagement is also important. That's why we need to build this relationship because there are misunderstandings about the concept. We need to discuss more on this issue. I thanked ISR's representative, His Excellency Edmond Bon Taishon, that he has also reflected here. And I particularly thank him because he participated in our last annual AMRIP sessions through the video message in our panel on the role of national human rights institutions advancing indigenous people's rights. I thanks on behalf of the AMRIP for your openness to raise all these points, all this discussion. And I think this is very valid point. And this is also the legal issue I understand in many states. But at the same time, this is also the opportunity to open up the discussion and engaging with the UN mandated bodies to advance the indigenous people's human rights. We need more dialogue. We need to build a partnership. Unless we don't have this dialogue, we don't build a partnership, we will continue doing this misunderstanding on the issues and also the respecting the rights of indigenous peoples. Then I'll stop here and sorry. If there's any question, we can discuss informally.
Yeah, thank you so much, Dr. Binotam Widamai, for your reflection as well as some of the points that are important for us to see how we can really continue the dialogue as well as the partnership with different stakeholders. So now with our final discussion, we have Dr. Pichamon Yupantong, our chair and also member of the working group, UN Working Group on Business and Human Rights. She's actually actively advised a range of civil society organizations, as well as NGO, government agencies, security, and also investment issues. I think we would like to hear from your views, discussion, and what will be the steps that we would like to strengthen in terms of accountability and also protection of the right of indigenous peoples. As we see the previous discussion or previous session, many of the participants also highlighted the point of mandatory. So maybe you can share this view as well. Yeah, please, the floor is yours.
Frederick just helped add another point that I will now have to find a way to include in my remarks, because I was editing my remarks quite furiously as I was listening to the very insightful and erudite interventions from colleagues here on this session. Well, first off, it's a real privilege to be part of this session and to speak about an issue that is often neglected, unfortunately, despite all of the dialogue that we had, despite all of the sessions we've dedicated to speaking about the importance of Indigenous peoples' rights and the need for businesses to respect these rights. I find that we are still, even now, talking about the same issues. Does that actually indicate change? Does it indicate progress? I can't say for sure anymore. But what I will say is this: the UN Guiding Principles on Business and Human Rights are meant to provide the global standard for preventing and addressing human rights impacts, adverse human rights impacts linked to business activities. We know that. We know that states have a duty to protect human rights, that businesses have a responsibility to respect human rights, and that together they need to provide access to effective remedies. But we also know that implementation continues to lag behind, especially in this region, and that the rights enshrined for Indigenous peoples in the UN Declaration on the Rights of Indigenous Peoples, including that of free, prior, and informed consent, the rights to lands, to territories, to resources, and the rights to self-determination, that those rights are still being infringed upon, if not violated outright, by states and by businesses in various parts of this region. The Working Group on Business and Human Rights has consistently highlighted that this gap between principle and practice is a big issue. Across every region, Indigenous communities continue to face, as we've heard already on this session, land grabs, forced displacement, environmental degradation, and the list goes on. These harms are not accidents. They are the predictable outcomes of the non-implementation of the UN Guiding Principles, where governments have failed to regulate, where companies have failed to conduct meaningful human rights due diligence, and where Indigenous voices continue to be excluded from decision-making processes. And so, to bring in the point that you raised, Frederick, about mandatory human rights due diligence, yes, it's necessary. We need a smart mix. We need a smart mix of both voluntary and mandatory measures. The question, however, is that even with mandatory human rights due diligence, are we sure that governments in this region will have the wherewithal to ensure enforcement? Because at the end of the day, regardless of whether a measure is voluntary or mandatory, enforcement, implementation, those are two key things that need to happen in order for us to ensure that human rights abuses are in fact addressed and, more importantly, prevented. So reflecting on what colleagues have already shared, allow me to highlight 3 further points that I'd like to make. Points that I think won't come as a surprise to colleagues sitting here in this room, but points that I hope colleagues will consider sharing with others outside of this room, those who aren't able to be with us today. First, free, prior, and informed consent, FPIC, must be understood as more than just a procedural step. It is a substantive right grounded in self-determination, and too often, FPIC is reduced to a box-ticking exercise with consultations held late in project design, information withheld, or consent bypassed entirely. This is not FPIC. Genuine FPIC requires early engagement, it requires transparent sharing of information, it requires the recognition that Indigenous peoples have the right to say no to projects that threaten their rights. Second, the failure to implement FPIC exposes structural weaknesses in how the guiding principles have been applied in this region as well. Human rights due diligence, as outlined or set out in the UNGPs, necessitates businesses to identify, prevent, and address impacts on Indigenous rights in a way that centers those most affected. Yet, what we see in many cases are businesses conducting risk assessments for investors or for other stakeholders, not for the rights holders themselves. And then remedy, when it does come, is often too little or too late. This gap points again to the urgent need for Pillar 3 of the Guiding Principles, access to effective remedies, to be enhanced, for it to be amplified by states as a primary duty bearer through binding measures that make respect for Indigenous rights by businesses non-negotiable, not optional. Third, we must recognize the cost of inaction. Where Indigenous rights are not respected, we see escalating conflict, we see broken trust, reputational damage, and projects that ultimately fail. But more importantly, we see irreparable harm to peoples who are stewards of the world's most biodiverse ecosystems. So protecting Indigenous rights in this context is not only a human rights imperative, it is also essential to sustainable development, to climate action, and to peace. And so looking ahead at the way forward, states must embed the rights of Indigenous peoples, including FPIC, into laws, policies, and national action plans on business and human rights. Businesses must ensure that FPIC is a non-negotiable element of their human rights due diligence processes, and they must also provide or cooperate in remedy when these rights are violated and or abused. Civil society and Indigenous leaders, many of whom are in this room, must be meaningfully included in shaping the frameworks that govern business conduct. And this is where, as my colleague from MRIC has emphasized, dialogue is absolutely necessary. The UNGPs, at the end of the day, are a framework for prevention. Yet prevention only works when implemented in practice, not just in principle. The continued disregard for Indigenous rights, particularly FPIC, represents not just a gap in implementation, but fundamentally a breach of trust in the promise of the UNGPs. And so as we think ahead and as we act in the future, we must ensure that business activity never comes at the expense of Indigenous peoples as it has in the past. We need to ensure that the rights of Indigenous peoples to self-determination, to their cultural survival, continues to be upheld. Protecting and respecting Indigenous rights is not an add-on to responsible business. It is a litmus test of whether the UNGPs are in fact being meaningfully realized in this region as well as in other regions. So with that, thank you very much again for inviting the working group to be part of this discussion. And in solidarity, I hope you will consider including us and sharing with us your concerns, because that is what helps to inform our work and our agenda. Thank you.
Thank you so much, Dr. Pichamon. With that note, we would like to conclude this session, and I really acknowledge the participation of all of you in person as well as online. I think more important is we need to continue the dialogue, not only with the right holder, Indigenous peoples, National Human Rights Institution, UN expert, but we also would like to working closely with different sectors like business enterprise, companies, even the government representative. I think this is something that we need to work together. Only with the dialogue and continued discussion is really key for us how we can work together as peoples in the planet. So with that, I would like to acknowledge everyone, all distinguished speaker and panelists once again. Thank you very much and have a good evening.